Hi everyone, my name is Evan Conroy. I'm an attorney at Conroy Law. This is a brief introduction for Indiana HOAs and condominiums seeking to collect assessments before a lawsuit is filed. So this will be the pre-litigation stage. First, we have the work performed by the community association before a law firm or a debt collection company gets involved. That includes things like sending out delinquency notices and entering into payment plans with delinquent owners. At this stage of the collections process, it's important that community associations have procedures in place to ensure that they treat every owner in the same manner. To do this, a community association should have a collections policy. Now, what is a collection policy? A collection policy is a set of documents that provide instructions to both the current as well as future boards on how collection matters are handled. If the community is professionally managed, then a collections policy will also be incredibly helpful for that management company to ensure it aligns its actions, its procedures with what the board wants to see happen year after year, treating similarly situated delinquent owners in the same or similar manner. For example, the collections policy should provide how many delinquency notices are sent out to homeowners before the matter is transferred over to a debt collection company or a law firm. If the amount of the charges or interest rate is determined by the board according to the association's declaration of covenants. Some declarations will just set whatever the late charge or whatever the interest is, but other sets of declarations will have like language that's based on the board's determination. Then you want to make sure that language, that determination, is in the collection policy, listing the amounts that have been approved by the board. The collection policy should also provide guidelines on the type of payment plans that a board is willing to accept, such as like the length of the plan, whether late charges or interest can be waived as part of the settlement discussion as part of a payment plan, whether there's an initial good faith payment that needs to be paid before there's a payment plan, things of that nature. If the assessments continue to go unpaid, the next step would be, of course, to transfer the matter to a company that performs debt collections work, right? A specialist who do this for a living. There are two types of debt collectors. One, it would be a law firm that performs debt collection work. The other is a debt collection business that is not a law firm, but they specialize in collections work. To keep things simple, I will be calling these types of companies that aren't law firms as debt collection companies, though the way they're both law firms and other types of debt collection companies are treated under the law, particularly under federal law, is very similar. They're all treated as debt collectors. Each type of business has its own benefits for a community, right? Each one has its pros and cons. A law firm is going to employ lawyers, and so they can practice law. This means that a law firm can prepare legal documents, it can file collections lawsuits, things of that nature on behalf of their clients. Additionally, there are going to be law firms that specialize in representing community associations, which should include at least one attorney within that firm that is comfortable handling collections litigation and post-judgment collections specifically for community associations. Often, these firms will either be paid by the amount of time the attorney or paralegal assigned to a matter, how much time they spend on the matter at their billable rate, or there'll be a flat fee charged for a particular task. That's more common when it comes to things like demand letters and recording of liens. Debt collection companies that are not law firms typically focus on those types of collections work that someone would think about when thinking about debt collection, right? Such as calling delinquent homeowners, sending letters, sending emails, the debt collection sort of work that most people think of when they think of debt collectors. One of the benefits of using a debt collection company is that they often have alternative payment arrangements, right? Sometimes they'll work on a contingency manner, which means that they don't get money until the association gets money and they get a percentage of that. Other collection companies will do a deferred fee based form of collections. Well, they won't charge you until you get paid. Or others will have some sort of cost splitting, things of that nature. While both law firms and debt collection companies have their own unique advantages, it's important to be sure to thoroughly review any engagement agreement with any company, not just collections company, but any companies that do business with a community association, just to make sure that one, the company that's being contracted with has the necessary experience, and then two, that the manner in which they operate aligns with the association's goals and the board's comfort level let's go more in depth on the sort of work that's going to be performed by a law firm at the pre-litigation stage. After a file has been created and reviewed for some initial possible roadblocks, things like the owner being in the military, because there's unique protections for active duty service members, checking for bankruptcy status. You don't want to be going after someone trying to collect a debt if they're in bankruptcy. After you get through those initial checks, a law firm would then typically send out an initial communication, an initial letter to the owner. This initial communication has really important ramifications for law firms and the collection process because there's a set of laws in place called the Fair Debt Collection Practices Act, often called the FDCPA. The FDCPA is federal law that has very specific requirements for debt collectors to follow, right? So they're going to make sure they comply with that law as part of the debt collection process. And one of those requirements is sending a letter with specific language in it. That's not necessarily a bad thing for associations hiring a law firm or a debt collection company, because that initial letter in itself can help motivate people to try to resolve the matter. Another benefit of these having to send these initial letters is that they tend to be relatively inexpensive. They're form letters that just makes the owner aware, among other things, that, hey, your matter's been transferred to a debt collection company. If that doesn't resolve the issue, the next step would be for a law firm to prepare a demand letter, essentially a more aggressive letter, along with typically recording a lien or notice of lien for the association. Notice of liens are very important. Closing firms typically find them as part of refinance or selling the property, and will want to pay off the debt if they're found. Another important reason to have these notice of liens or liens is to ensure that if someone files for bankruptcy, the debt is viewed as secured debt. That's incredibly important for example, Chapter 13 bankruptcy filings. Another reason that a great benefit for recording a lien or a notice of lien if you're a condominium association is that it just informs the owner that you mean business. Their property is now encumbered for the whole world to see by that unpaid amount that's owed. Let's now focus on some important requirements that must be followed when preparing and recording an HOA lien in Indiana. This is very specific Indiana law in this point, so if you're watching this video and your association's in a different state, this part probably won't apply to you. Maybe some of the broad concepts will, but not the details. This is very specific Indiana law. So, for example, in Indiana, for HOAs, the lien that is encumbering the property only takes effect when the actual lien document's recorded. So you don't want to wait to prepare a lien. The lien doesn't automatically spring into existence for HOAs. You need to actually record something in the land records, and that document needs to align with the applicable requirements. So this is really important. This is also important because you want to make sure that if the property is about to get sold, that the document's recorded so that if a new owner buys the property, they can be jointly and severally liable for the debt, assuming it's recorded before the sale takes place. It's also important to note in Indiana there are time constraints related to the recording of liens, and you need to make sure there's big consequences if you're not being mindful of those time constraints. For example, a foreclosure complaint cannot be filed earlier than 90 days before the lien is recorded, with some exceptions, right? So if another party forces the association to do so, then there's language in the Indiana statutes that permits filing the action earlier, but typically it's 90 days. Also, once a lien is recorded, the clock starts ticking for when the association has the ability to file a foreclosure complaint. If they don't do it timely, the lien becomes void. There are also specific requirements for how HOA liens are to be prepared. It needs to include the name and address of the HOA. It must also include the address and a legal description of the property that is going to be subject to the lien. You must also include the name of the owner of the property that is subject to the lien, as well as the amount of the lien. Additionally, you need to make sure that it is signed, that the lien is signed by an officer of the HOA and appropriately acknowledged with the proper language for the acknowledgement. As you can tell, there are a lot of particulars that the association needs to get right in order to have a proper lien recorded, which is why it's often very helpful to have a law firm involved in helping make sure that the lien is properly prepared and recorded. Now, condominium liens in Indiana are different. They're subject to a different part of the Indiana code, so they're just very different. A major difference is that condominiums enjoy an automatic lien, so that the lien springs into existence when an assessment goes unpaid. You don't technically have to record a document to have a lien. Now, it's a very good idea to go ahead and file a notice of lien. Again, for some of the reasons we talked about before. A big one is that closing firms, they see those things. They see the notice of liens, and it helps better ensure that the lien does get paid if there's a refinance or a sell of the property. And for that reason, I strongly encourage condominium associations to go ahead and have notice of liens prepared and recorded. They're inexpensive, relatively speaking, or they should be, and it helps ensure that people are aware of the encumbrance. Now, I've been saying the word recorded a lot, or recording. Let's briefly take a moment to talk about what it means to have something recorded. Right. So a document is recorded when it's provided to a county's recorder's office for processing. They're going to place it in the land records. If it's accepted, they'll mark the document with the date it was recorded and make it available to view as part of, for anyone to view as part of the land records. There are two ways to submit a document for recording. The traditional old school ways to go in person or mail the original document to the recorder's office. Then in the old days, they'd have a physical stamp to record it, to mark it as recorded. However, the more common way to do it now is to have the document e-recorded. This has become increasingly the preferred method around the nation. It's faster. It just makes more sense to do it electronically, and that's what a lot of counties have moved to, including Hamilton and Marion County and other counties in Indiana. Now, let's talk about what happens when a delinquent owner actually reaches out and says, hey, I want to enter into a payment plan during this pre-litigation phase. Like we've previously talked about, it's important to treat owners in the same way or similar way as other delinquent owners. So you want to make sure that during the settlement negotiation about trying to get this debt resolved, whether it's a payment plan or just a settlement payment, that it aligns with your collections policy. With any sort of settlement, payment plan, whatever, it should be in writing. This is important to avoid confusion between the parties because the requirements of what needs to be done to resolve this matter are in writing so that people can review back to it if needed. And worst case scenario, if it's signed by the parties, it's potentially legally enforceable if you have to take it to court. There are things that are important to put in a payment plan or some sort of settlement agreement, include like when payments are due, how payments should be sent, how payments can be made. Can it be made with certified funds, personal check, ACH, those sorts of things. Other things to talk about is, what happens when there's a failure to timely make your payment, right? Is there a cure notice that needs to be sent out, like to let the owner know they're delinquent? These sorts of things are important to ensure, again, there's not ambiguity between the parties about what their relative obligations are pursuant to the terms of the payment plan. Now, given all this work that we've been talking about, like what happens next? One, hopefully the debt gets paid off. The owner comes forward, they want to pay off the debt, great. If that happens, then there's going to be a lien release and you're going to be done with it if there's a lien file. Two, the owner does not pay off the debt, at which point the association will need to figure out if it makes sense to move forward with litigation or strategically if it should wait a year, come up with a game plan. Finally, one other thing that could possibly happen is the owner could file for bankruptcy. This is pretty uncommon at the pre-litigation phase, but it does happen. If that occurs, then you'll want to make sure that the association takes part in the bankruptcy proceeding. Oftentimes, it's helpful to have a law firm involved so they can monitor the bankruptcy proceedings to try to advocate on behalf of the association. If the matter goes to bankruptcy, it's very important, as we talked about before, hopefully a lien's been recorded prior to the bankruptcy filing, because that'll be incredibly helpful, particularly if it's a Chapter 13 bankruptcy proceeding, which if you want more information on that, please watch our video on bankruptcy filings. Well, thank you for taking time to watch this video on the pre-litigation collections for HOAs and condominiums in Indiana. If you'd like to learn more about other community association topics, please feel free to check out our other educational videos. Regardless, I just want to say thank you for taking the time to watch this video, and I hope you have a great day.